Hello, I am Surya Subedi. I am Professor of International Law and the author of the study guide on International Law of the Sea. Today, I will discuss very briefly what I have included in section A of the study guide. As you know, there are 4 sections in the study guide, section A, B, C and D. Each of the sections are devoted to certain areas of the law of the sea, and section A deals with the evolution of the law of the sea, how we came into this position, how the law has developed over centuries actually, seafaring activity, venturing out into the seas and oceans of the world, exploring the unknown territories and establishing trading relations, other economic relations with people in far away land has been a human occupation for a long time. How these activities, the trading relations between different countries around the globe has taken place over the centuries is the focus of this section, section A. I begin my analysis with an examination of the law and practice in a rudimentary form, not as well developed as we have today, but in a rudimentary form was in existence in antiquity. How states were regulating the conduct of maritime trade basically at the time. That is how I begin the study guide, section A. Then I move on to the Rhodesian law, how the people in Asia Minor, the Rhodes Island, first countries of the region to have some form of codification of the law regulating maritime trade, the trade between people from different countries. Then we move on to the period of Hugo Grotius, known as the father of international law. Until that time, the seas and oceans were free for all, but there was a gradual attempt to enclose the seas, require other states to pay a tax, some sort of a levy to use the seas and high seas. By a papal decree, the world was divided into 2 halves, one belonging to Spain, another belonging to Portugal. So, these 2 states were trying to control maritime trade, saying that the seas and oceans belong to them, and other states or traders from those states which wanted to use the sea lanes had to pay tax or accept the terms and conditions imposed by these countries. Hugo Grotius, relying on certain Roman law principles, some natural law principles, came up with the idea of the freedom of the high seas. No, they are the gift of God to all of us. So, there is no question of a state exercising sovereign rights over the vast areas of seas and oceans, in which the states could not even exercise effective control. If you cannot exercise effective control, why should you have a claim of sovereignty? That time even 3-mile cannon rule, the maximum reach of a cannon, the firepower was 3 miles. Beyond 3 miles, how can you exercise control over that area of the seas and oceans? So, he was the first one to champion the idea of the freedom of the high seas. That was the time 1625, 1630, 35, during that time there was a great deal of debate going on within Europe, whether the seas could be closed to the major maritime powers of the day, or the seas had to be open for use by all nations, whether landlocked or coastal states. The argument advanced by Hugo Grotius won the day, and the attempt made since then has been to ensure that the freedom of the high seas is enshrined in a treaty applicable to all states. As an attempt in that direction, there was a very important conference taking place in The Hague in 1930, the first ever attempt to codify the law, the rules of the law of the sea into a treaty. But unfortunately, for a number of reasons, the Hague Peace Conference of 1930 did not conclude a treaty. Then we had the start of the Second World War, that brought us different experience, taught different lessons, and actually made the need to have a proper regulation of the use and use of the seas and oceans stronger. As a result of that one, soon after the establishment of the United Nations, the World Organization embarked on an ambitious program to conclude treaties regulating the activities of states in the seas and oceans. In 1958, a major diplomatic conference took place in Geneva, and 4 major instruments in the form of conventions were adopted, but again they too were not comprehensive enough. The outer limit of the territorial sea, for instance, could not be agreed. So, as a result of that one, the debate began within the United Nations how to conclude another comprehensive convention, and it was also in the 1960s the discovery that the ocean floor was rich in mineral resources. How to exploit an state system when they knew that the ocean floor was rich, there was an attempt to encroach upon it, to bring it within the jurisdiction of powerful states. So, there was an attempt made within the United Nations to declare the whole ocean floor, the high seas, a common heritage of mankind. What do we mean by the common heritage of mankind? How do we exploit the resources of the sea for the benefit of the humankind as a whole was the challenge. So, the course goes on to analyze the developments that took place in the 70s, and then resulting finally in the conclusion of a comprehensive convention on the law of the sea in 1982. So, that is very briefly a historical overview of the evolution of the law of the sea. The evolution has not stopped there. Even the 1982 convention, some of the provisions are not adequate today. For instance, piracy of the coast of Somalia, Kenya, or in the states of Malacca, there are a number of challenges posed by modern human activity. Terrorist activities, use of the seas and oceans by terrorists for terrorist purposes has been a concern of the international community. Also, the exploitation of the fisheries resources. There should be a proper mechanism to manage and conserve, so that we are not exploiting the fisheries resources just for our generation, leaving nothing for the future generation. The law has to make sure that the exploitation of the fisheries resources is carried out in a manner which is sustainable and which leaves something for the future generation, which leaves something for the fish stock to grow and grow, so that no future generation will be deprived of the opportunity. So, these are the areas I have examined in this section of the course on international law of the sea. Thank you.